The law is complex, but it doesn't have to be a mystery. We are talking legal literacy, not advice. So don't worry, you're not getting an invoice. I'm Simon Jenga, and welcome to Simon Says. Today we are talking about your disclosure obligations, what you have to say and when you have to say it. There's a variety of different circumstances that you are going to be required to disclose information in. The purpose of today is not to go over every single one, talk about the legal requirements, talk about the legal consequences. Instead, what we're going to do is just go through a few examples and really draw attention to the fact that there is often disclosure obligations, and you being aware of those obligations is going to assist you in contracting better overall. So some examples that we might look at are property transactions. Could be the sale and purchase agreement, it could be your KiwiSaver application, your agency agreement with your real estate agent, your loan application with the bank. Or if you're dealing with a government department, then it might be a subsidy application for rest home care, your WINS or other benefit application, some other MSD application, or your pension. All of these situations are giving rise to times when you will be asked for information and the obligation arises to be honest, truthful, and tell the full story. Now, this doesn't mean that you need to dig the hole to bury yourself in. But what it does mean is that you need to make sure that when you are saying information, that you are complying with your legal obligations so that a negative consequence won't find you. Now, what could those negative consequences be? Okay, if we take a standard contract, and it would be subject to the Contract and Commercial Law Act 2017. There's a few things that could go wrong if you don't say something when you know it. So the other party could claim mistake, that they entered into the contract mistakenly believing X when you knew the position was Y. They could also claim misrepresentation, that not only did you present the position as you thought it to be, but you knowingly presented a false or incorrect position, in which case they relied on you and your false representation to enter into the contract. The other avenue that's available, or other issue that could arise, is the contract being frustrated. Now, that is not you being mildly disdained by the contract. A frustrated contract is a contract that it turns out is unenforceable for some reason. One of the underlying facts is so different to what the parties thought that the contract is frustrated, it can't be performed. All of these add up to a contract that could be voided or terminated. You could be liable for damages or losses to the other party, and that won't be limited to just the subject of the contract, it could be limited to consequential losses, which means that even though you've only contracted with Bob to sell him 100 kilos of raspberries, the fact that he was going to use those raspberries to make pies and already had a contract to on-sell those pies, he might be able to claim his losses for breaching that contract back on you. It's all going to come down to the wording in your contracts and the egregious nature of the non-disclosure of information. Another specific example is relationship property, contracting out agreements or separation agreements. In both instances, there's an obligation to disclose relationship property and personal assets so that it can be determined what property falls into the relationship property pool and what property is separate property. Now, if you breach those duties of disclosure, now as a slight sidetrack, disclosure is different to discovery. Discovery is a term that if you are enthralled in litigation right now, you will have heard from your lawyer the term discovery. We're not talking about that for the purposes of the courtroom. We're talking about disclosure obligations, which falls on you personally in the context of preparing and finalising those relationship property agreements outside of a court process. When you go through that process, that agreement is only enforceable if it stands up to the legal requirements in the Property Relationships Act 1976. One of the provisions in that act is that if the agreement causes serious injustice, then it can be voided. Now, if you're relying on that contract to keep certain properties separate and outside of a relationship, then that is going to be a major issue for you if that agreement is thrown out. So, disclosure, full, upfront, is going to be important to making sure you've got a valid relationship property agreement. Overall, the question to ask yourself is, do you know what is required of you in terms of disclosure? And if not, then you need to talk to your trusted legal advisor to confirm those requirements. What you don't want to do, just as much as under disclosing, is over disclose. And as I said earlier, digging your own grave. Sometimes there's no obligation to disclose. You won't know unless you've got confirmation, and my recommendation is to get a trusted legal advisor to make that determination for you, if only so you have someone to blame for that advice rather than relying solely on your own judgment. One of the things that comes up fairly regularly is, but Simon, they'll never find out. How could they possibly know that I knew that piece of information? Or how could they possibly know that we didn't live in the property for the 6 months required? Or how could they possibly know that last season it flooded in that portion of the garage? That is a you decision. If you want to run the risk of them finding out whatever it is that you haven't disclosed and it impacting the validity of the document and the financial consequences that you might incur, then that is a you decision. You can totally make that call. There's going to be limited times that once your legal advisor knows about certain information that they cannot continue to act for you without disclosing. So an example would be in relation to anything to do with the bank. As soon as I'm aware of something that's prejudicial or is going to be harmful to the bank's position, then I've got an obligation to disclose. So sometimes it's going to be my call as to whether I'm able to continue acting despite your instructions around disclosure or non-disclosure. But for the vast majority, it is going to be a decision that you get to make around what risk you're prepared to take on in order to preserve or achieve a certain outcome. So today, Simon says, whatever disclosure you decide to make, you are choosing what risk you are or aren't taking on. If you've enjoyed this podcast, then please hit those like and subscribe buttons. If you like what you've heard and think that one of your mates might benefit from this advice, then forward on this video. And remember, at LOA Law, we are good lawyers for good people.